The Data Privacy Act of 2012 protects all forms of information that are personal, private, or privileged. It covers all persons, whether natural or juridical. It is the policy of the state to protect the fundamental human right of privacy of communication while ensuring free flow of information to promote innovation and growth. The state recognizes the vital role of information and communications technology in nation building and its inherent obligation to ensure that personal information in information and communication system in the government and in the private sector are secured and protected. What is considered as personal information? Personal information refers to any information, whether recorded in a material form or not, from which the identity of an individual is apparent or can be reasonably and directly ascertained by the entity holding the information, or when put together with other information, would directly and certainly identify an individual. Differentiate sensitive personal information from privileged information. Sensitive personal information refers to personal information about an individual's race, ethnic origin, marital status, age, color, and religious, philosophical, or political affiliations. It also talks about an individual's health, education, genetic or sexual life of a person, or to any proceeding for any offense committed or alleged to have been committed by such person, the disposal of such proceedings, or the sentence of any court in such proceedings. It also covers information issued by government agencies peculiar to an individual, which includes but not limited to social security numbers, previous or current health records, licenses or its denials, suspension or revocation, and tax returns. Also, it covers information specifically established by an executive order or an act of Congress to be kept classified. On the other hand, a privileged information refers to any and all forms of data which, under the rules of court and under pertinent laws, constitute privileged communication. Are all sensitive personal information protected under the Act? No. This Act does not apply to the following. First, the information about any individual who is or was an officer or employee of a government institution that relates to the position or functions of the individual, including the fact that the individual is or was an officer or employee of the government institution, the title, business address, and office telephone number of the individual, the classification, salary range, and responsibilities of the position held by the individual, and the name of the individual on a document prepared by the individual in the course of employment with the government. Also, it does not cover information about an individual who is or was performing service under contract for a government institution that relates to the services performed, and information relating to any discretionary benefit of a financial nature, such as the granting of a license or permit given by the government to an individual. It also do not cover personal information processed for journalistic, artistic, literary, or research purposes. Information necessary in order to carry out the functions of public authority, and information necessary for banks and other financial institutions under the jurisdiction of the Independent Central Monetary Authority or Bangko Sentral ng Pilipinas. And finally, it does not cover the personal information originally collected from residents of foreign jurisdictions in accordance with the laws of those foreign jurisdictions. This affect acts done abroad. This act applies to an act done or practice engaged in and outside of the Philippines by an entity if the act, practice, or processing relates to personal information about a Philippine citizen or a resident. The entity has a link with the Philippines and the entity is processing personal information in the Philippines, or even if the processing is outside the Philippines, as long as it is about Philippine citizens or residents such as, but not limited to the following. A contract is entered in the Philippines. A juridical entity unincorporated in the Philippines but has central management and control in the country, and an entity that has a branch, agency, office, or subsidiary in the Philippines, and the parent or affiliate of the Philippine entity has access to personal information, and the entity has other links in the Philippines, such as, but not limited to, the entity carries on businesses in the Philippines, and personal information was collected or held by an entity in the Philippines. What are the rights of the individual whose personal information is being processed? A data subject refers to an individual whose personal information is processed. The data subject is entitled to the following. First, be informed whether personal information pertaining to him or her shall be, are being, or have been processed. Second, before the entry of his or her personal information into the processing system of the Personal Information Controller, or at the next practical opportunity, be furnished with the following information: the description of the personal information required, the purpose or purposes of getting the information, the scope and method of processing the information, the recipients or classes of recipients to whom they are or may be disclosed, the methods utilized for automated access if the same is allowed by the data subject, and the extent to which such access is authorized, the identity and contact details of the Personal Information Controller or its representative, the period for which the information will be stored, and the existence of their rights, for example, to access correction, as well as the right to lodge a complaint before the Commission. What are the prohibited acts under the law? First, we have the unauthorized processing of personal information and sensitive personal information. The unauthorized processing of personal information shall be penalized by the imprisonment of 1 year to 3 years and a fine of not less than 500,000 pesos but not more than 2 million pesos. On the other hand, those unauthorized processing of personal sensitive information shall be penalized by imprisonment ranging from 3 years to 6 years and a fine of not less than 500,000 pesos but not more than 4 million pesos. Second, we have accessing personal information and sensitive personal information due to negligence. Accessing personal information due to negligence shall be penalized by imprisonment ranging from 1 year to 3 years and a fine of not less than 500,000 pesos but not more than 2 million pesos. On the other hand, accessing sensitive personal information due to negligence shall be penalized by imprisonment ranging from 3 years to 6 years and a fine of not less than 500,000 pesos but not more than 4 million pesos. Third, the improper disposal of personal information and sensitive personal information. The improper disposal of personal information shall be penalized by imprisonment ranging from 6 months to 2 years and a fine of not less than 100,000 pesos but not more than 500,000 pesos. On the other hand, the improper disposal of sensitive personal information shall be penalized by imprisonment ranging from 1 year to 3 years and a fine of not less than 100,000 pesos but not more than 1 million pesos. Fourth, processing of personal information and sensitive personal information for unauthorized purposes. The processing of personal information for unauthorized purposes shall be penalized by imprisonment ranging from 1 year and 6 months to 5 years and a fine of not less than 500,000 pesos but not more than 1 million pesos. On the other hand, the processing of sensitive personal information for unauthorized purposes shall be penalized by imprisonment ranging from 2 years to 7 years and a fine of not less than 500,000 pesos, but not more than 2 million pesos. Fifth, unauthorized access or intentional breach. The penalty of imprisonment ranging from 1 year to 3 years and a fine of not less than 500,000 pesos but not more than 2 million pesos shall be imposed on persons who knowingly and unlawfully or violating data confidentiality and security data systems breaks in any way into any system where personal and sensitive personal information is stored. Sixth, concealment of security breaches involving sensitive personal information. The penalty of imprisonment of 1 year and 6 months to 5 years and a fine of not less than 500,000 pesos but not more than 1 million pesos shall be imposed on persons who, after having knowledge of a security breach and of the obligation to notify the Commission pursuant to Section 20, intentionally or by omission conceals the fact of such security breach. Seventh, malicious disclosure. Any personal information controller or personal information processor or any of its officials, employees, or agents who, with malice or in bad faith, discloses unwarranted or false information relative to any personal information or personal sensitive information obtained by him or her shall be subject to imprisonment ranging from 1 year and 6 months to 5 years, and a fine of not less than 500,000 pesos but not more than 1 million pesos. And finally, unauthorized disclosure. Any personal information controller or personal information processor or any of its officials, employees, or agents who discloses to a third party personal information not covered under malicious disclosure without the consent of the subject data or data subject shall be subject to imprisonment ranging from 1 year to 3 years and a fine of not less than 500,000 pesos but not more than 1 million pesos. And any personal information controller or personal information processor or any of its officials, employees, or agents who discloses to a third party sensitive personal information not covered under malicious disclosure without the consent of the data subject shall be subject to imprisonment ranging from 3 years to 5 years and a fine of not less than 500,000 pesos but not more than 2 million pesos. Can a corporation be held liable? Yes. If the offender is a corporation, partnership, or any juridical person, the penalty shall be imposed upon the responsible officers, as the case may be, who participated in, or by their gross negligence, allowed the commission of the crime. If the offender is a juridical person, the court may suspend or revoke any of its rights under this act. What if the offender is not a citizen of the Philippines? If the offender is an alien, he or she shall, in addition to the penalties prescribed, be deported without further proceedings after serving the penalties prescribed. What if the offender is a public official? If the offender is a public official or employee and he or she is found guilty of acts penalized under the Act, he or she shall, in addition to the penalties prescribed herein, suffer perpetual or temporary absolute disqualification from office, as the case may be. Now let's take a look at Cadahas versus People. In the case of Cadahas versus People, petitioner and victim AAA got into a relationship while they were 24 and 14 years old, respectively. AA's mother learned about the relationship and found that petitioner was coaxing her daughter to send him photos of the latter's breast and vagina. So, she sued petitioner and used the exchanges extracted from petitioner's messenger account as evidence in court. Petitioner was convicted of the crime of child pornography. Among the evidence presented against him were photos and messages taken from his Facebook Messenger account by the minor's parent. It turns out he had given the minor access to his own account. This allowed the latter to give her mother the same access after being pressured to do so. The assertion of the accused was simple. The materials were obtained in violation of his right to privacy and should have therefore been inadmissible as evidence in court. However, the court disagreed. Initially, it went on to discuss the right to privacy, taking particular interest in the aspect of informational privacy. It then declared that the right, as enshrined in the Constitution, only protects private individuals from government intrusions, not from the prying eyes of other private parties. In the latter case, it is the Civil Code, the DPA, and other pertinent laws that apply. The court spent some time explaining why the processing of personal data that occurred in connection with the case was proper and allowed under the DPA. It cited two specific reasons. First, it related to the determination of criminal liability of the person involved, and it was necessary for the protection of lawful rights and interests of persons in court proceedings. It capped things off by bringing up the reasonable expectation of privacy test and showed why, when used in the case, it proved that there was indeed no privacy violation to speak of.